Hello, welcome to the second season of the Digital Rights Africa podcast, where we talk about everything data governance, data protection and privacy, cybersecurity issues, and intellectual property in Africa. I am extremely excited to be joined by a friend and the regulator of data protection in Mauritius, Mrs. Madhub. Drudeisha, thank you very much for joining us on this set. I'm extremely excited to have you here. The reason that you're here is so that we can really talk about an important issue on the continent around data protection and around what you're doing in Mauritius. Maybe by way of introduction to our audience, can you just tell us a bit about your role, how long you've held it for, because you're one of the longest serving and also one of the youngest regulators to have come into the scene, and how things are going in Mauritius.
Great. I'm also very happy to be joining you today, Teki. And I've been commissioner for the past 14 years.
Wow.
For Mauritius. Actually, the first commissioner for Mauritius, and since I'm in a permanent position, so I'm still the commissioner. And when I started data protection in 2007, actually I was at the state law office before. I was senior state counsel for 7 years. It was something just kind of a, I must say, luck or fated decision that I made, because data protection, even 14 years ago, yes, in the African continent and in Mauritius, was something that no one actually knew about.
Yeah.
And what the word meant in the IT sphere was just cybersecurity.
Exactly.
And not data protection.
Exactly.
So when I started, actually, I was educating a whole population, let's say a whole uneducated population in data protection, including our policymakers, legislators, and everyone involved in the production of a data protection story. So I actually started by drafting the amendments to be brought to our 2004 legislation, which was not yet in force and which was a chaotic piece of legislation.
Because I was actually going to ask you if you were in a space where a lot of people did not understand that. What kind of law did they pass then?
Exactly the point. When I looked at because I'm a human rights expert, I'm specialized in human rights and also to some extent IT, very well versed. So when I looked at the 2004 legislation that we had, I was saying to myself, I will be offending many, many people because it's literally something which is not workable. And I believe there are many countries which are still, on these outdated principles with these types of legislations in the world currently. And that is something which is very tragic, because these types of models have been inspired from other jurisdictions.
Definitely.
It just didn't happen that in 2004.
I was actually going to ask you, so what really prompted Mauritius to go the route of data protection as early as 2004?
All right. Okay. Mauritius has always been in the forefront of innovation and making things happen in the legislative arena. And there are so many laws that were passed well before 2004 in the cybersecurity world, and data protection was one of the elements that was missing. And being given that we have huge foreign investment from Europe, so definitely that really made drive Mauritius to bring a legislation which will suit the European needs as well in terms of economic benefits and also protection of human rights, including privacy.
So definitely for a country maybe that is looking to increase trade and services between itself and possibly Europe or other jurisdictions that take data protection seriously, then it's an important thing to consider.
Absolutely, absolutely. And Mauritius was known at that time in 2004 as a cyber island, the first cyber space in the African continent. And to live up to that reputation was really having data protection on board.
How has bringing on board data protection into Mauritius really transformed your country's economy? I know that a lot of the time when we talk about data protection as experts and we're trying to convince policymakers that these issues are extremely important and it has direct connotation on socioeconomic development, they don't see that. Do you have like learnings that you can lend to us from Mauritius that has really linked these two ecosystems together?
Right, great. I think Mauritius, if you see over the past 14 years, like since we started this office, the rankings globally and internationally have radically rocketed up. And I think this is also due to the contribution of having the right data protection framework in Mauritius. And especially the office has been given a lot of, I must say, international credibility and credence in terms of the work that we have been doing over the past 14 years in terms of, as I said before, international jurisprudence being reproduced in our judgments, and the many judgments that we produced ourselves in our own jurisdiction, the guides that we have developed, the tools that we have developed to sensitize people on their rights, and basically working a lot with the industry in having the right policies and mechanisms in place for them to flourish in business, but with a sound and healthy data protection framework.
So definitely there's a lot for countries to gain by having the right frameworks in place, without. Having said that, we, a lot of the time across Africa, and I know you've seen this, we push for laws and laws, even your own experience with the 2004 law, and invariably sometimes the laws itself lack the requisite maybe principles or requirements or obligations that can really enable. And sometimes we also have the right laws and we're not really pushing for enforcement. Mm-hmm. How has Mauritius really been able to distinguish itself from some of these some of these things that I think are challenges?
I took the responsibility as regulator to be amending the law myself. The 2000 law was amended by my own contribution and then vetted, by the State Law Office and other, relevant stakeholders putting in their views. But I was the one driving the amendments. Why I thought it was very important that this particular, responsibility stays with me, because it's expertise, right? Data protection is not something that you would legitimately require all the people to understand and just draft a law and make it happen. This is why the practicality and sound principles, let's say also legal certainty, is being threatened in data protection laws, because sometimes what we do is we unfortunately just copy and paste from other jurisdictions because we lack the knowledge to be able to make our own. And we do understand that as well. It's not like we were meant to know how to tackle these laws, because it's new to us. But suddenly, like when we want to do something in data protection to make sense, we have to be able to bring our own contribution to the law. I will give you an example. The second laws for Mauritius, the second set of laws in data protection, was enacted in 2018. And we completely removed the old legislation because it was already not fitting the environment. There were many issues in practice that cropped up, and we wanted to simplify and give a user-friendly framework to our people. And I also drafted that legislation. But it was inspired from the EU GDPR. All right, so in EU GDPR, we had 99 articles, right? And we couldn't, in our context, put 99 articles and make such a huge legislation for such a small population of 1.2 million people. So what did I do was actually I said, no, let's simplify all these requirements in the GDPR and let's make it customizable, you know.
True.
And this is what I did, and I think it is one of the simplest legislations in data protection that you have across the world.
Yeah, but I mean, you speak because you have the expertise, right? So what about a country that is coming up that has no expertise whatsoever? And I have seen situations where sometimes, you know, our governments actually hire foreign experts to come and draft these laws, usually without even a complete understanding of how the society, the nuances of our societies and how things work, which also affects that. So how do you think we can navigate this challenge around having the right expertise?
I must say that I've been offering technical assistance to many countries in Africa, because I believe we share that, you know, common brotherhood, and we have so many commonalities as well. And Rwanda, Uganda, Kenya, to some extent Tanzania, Eswatini, many other countries in Africa, following now the SADC model law, of which Mauritius is also a member, which is highly inspired from the Mauritian legislation. And to that extent, many people, many countries are looking up to criminal prosecutions. The only country in the world which has criminal prosecution, as you're aware, Teki, is Mauritius. So now if you look across Africa, you will see many countries following that example. So it just happened. It's not like we wanted to lead as such, but we believed that taking the right approach will certainly benefit not only Mauritius, but also many other parts of the world. Because let's say we have EU GDPR, we have Convention 108, we have some Asia-Pacific rules, we have UN guidance, but we do lack, you know, this pragmatic approach to data protection in terms of laws. Okay. And this is something that probably Mauritius has innovated upon.
You just excited me by saying the word criminal sanctions. And I just want to use that to move us into the area of enforcement, right? I know that you're doing quite a bit in spite of having criminal sanctions. There's been some very interesting judgments that have emanated from your office that have run through the court systems and gotten the nod of the highest courts of your land as well. And, you know, so usually I have worked in the data protection institution that is also embattled with, I say embattled because I think it is a bit of a challenge when it comes to enforcement of the criminal sanctions from the data protection perspective, you know, where there could be other forms of sanctions, which usually we don't have in most of our laws. So how have you really managed to navigate this space of criminal sanctions, your rulings, and you know, just navigated that whole system in spite of having some of these things that I think are challenging?
I will start by saying, Teki, that, you know, data protection is about protection of fundamental right to privacy. We all know. So this is our main goal and not prosecution.
Exactly.
Although, like, criminal sanctioning is part of the system and we have to follow the rules and procedures. But our main ambition is to protect people without really hurting them. All right? So including controllers and processors. So what I did now, because I realized, like, you know, prosecuting so many people will not be an easy task.
Do you even have the capacity to do that?
Okay, I will come to that question. So what I did was introducing in the law amicable resolution of disputes. Which means that we don't need to go for prosecution. We reach like an out-of-court settlement, like, you know, in common legal jargon, and we have been solving so many cases without going for prosecution, without even going, you know, needing to do a formal police inquiry in collaboration with the police. And we have solved many with the correct remedial action being taken. And how do I go about prosecution now? yes, I don't have the required resources right now. But in our law, if we need the assistance of the police for criminal inquiries, statements being recorded, all the proper police statements being recorded in the proper prosecutorial fashion, we solicit the help of the police.
Okay.
I have the power to delegate this particular function to the police. And I've been working all my criminal inquiries for this year in collaboration with the police, because ultimately it goes to the Director of Public Prosecutions.
Exactly.
And this is not a joke. So we need proper police assistance to be able to reach to that level. So this is how we're working in collaboration with our law enforcement agencies.
Wow.
Yes.
So tell me about compliance and how you have approached this issue, this very critical issue in Mauritius.
All right, compliance has so many, facets. And one of the most important facets in compliance, what we have are the compliance audits, the security checks, data protection impact assessments, certification, etc., amongst other, activities that we regularly conduct, including enforcement notices, information notices, and other orders that we can seek through courts to be able to get the evidence, for example, preservation orders from judging chambers. So many compliance ways to achieve compliance, which are provided in the Data Protection Act. I cannot say that we do not have enough tools for compliance to be efficiently done.
Wow. We could go on and on and on and on, but I think all too soon we've come to another end. If you have maybe some parting words for colleagues, for private sector, others that are watching, what would be your parting words?
I would just say, please do not fear data protection. And because the right approach to data protection means the survival of your business. And that would be my
Thank you very much. You heard it from Ms. Madhub. Please do not fear data protection. We look forward to having you on another episode of the Digital Rights Africa podcast, where we discuss everything data protection, privacy, cybersecurity issues, child online protection, and intellectual property issues in Africa. Thank you. See you another time soon. Bye.